following is the summary brief submitted by my attorney, Bob Auler, at the divorce. And this is what is on file. In the Circuit Court of the 6th Judicial Circuit, Champaign County, Illinois, in reason, the marriage of Gloria J. Clay, petitioner, versus Ernest H. Clay, respondent, number 86C 540, written argument. Introduction. This case presents one of the most complicated financial intrigues in recent domestic relation cases. Because of the changes in representation, it also presents unexplained orders, which are perplexing in conception and problematic in application. Principally, the as-is provision and the partial order disposing of property entered by this court. It seems difficult to square with modern concepts of two estates of non-marital property and the emerging jurisprudence of what is marital, to go ahead and exchange numerous pieces of real estate without any values placed on them midway through a dissolution proceeding, and then to label the transfers as is without extensive clarification as to how that term is applied to a calculation of the values, whatever they are, of the exchanged parcels, and the effect of these unevaluated partial transfers upon the court's obligation to divide the entire marital estate fairly. This point was raised by Mrs. Clay at the inception of the hearing by means of a motion in Lyman, attempting to get clarification of what was meant by the as-is language and its effect upon her intentions to offer evidence on over $120,000 of expenditures she made after the marital breakup to preserve the marital property. She contends that these expenditures work in equity on her unless she is in some way reimbursed for them. Time and time again, in the presentation of this case, both sides have been tempted to offer proof on claims which appear to go behind the provisions of as is and to fly in the face of the court's ruling on the motion in Lyman. Quote, I have to conclude, and I do so conclude and rule, that the agreement between the parties allocated these properties as is, with no further claims or assertions of contributions earlier in the marriage. I don't see that there is now an opportunity to somehow go behind this and assert that there may have been infusions of cash by the parties during the marriage into the property. I think that opportunity is precluded. I think the parties settled these properties and accepted them with the debts on them when they allocated them by their own agreement. August 26th and 8th to the 9th. The problem, as it emerged during the hearing, however, is the fact that there is no clear idea as to whether it is an equal exchange, and we maintain that it was not because Mrs. Clay had no idea that it would preclude her from seeking reimbursement for over $120,000 in funds she spent to preserve the property. It is not too late to correct the error inheriting this unorthodox partial exchange without values, and to correct the inequities since the orders entered are clearly within the rest of the court. Mrs. Clay wishes to urge the court in the most persuasive language possible the absolute disaster she has observed in her personal life and in the lives of her children over this thorny divorce. The aspiration of a family for a middle-class existence, or better, for their children, have been shattered by whatever happened here. And the news that she can't expect any reimbursement for $120,000 she spent to save hopes for a better future for her and her daughters, and even for her ex-husband, is difficult for her to understand, notwithstanding the pithy, as is, of the unconventional March 5th order. 1. Child support. The key to the child support issue is 6E of the March 5th, 1997 order entered by this court, which provided that child support, both retroactive and future, was yet to be resolved. Mrs. Clay has been receiving $375 a month pursuant to this court's temporary support order, in which the court stated that the $375 was based on respondent's net income and applying the statutory minimum for 3 children and taking two-thirds of that figure, respondent is ordered to pay to petitioner $375. Page 10, February 16th order. We contend that this order was erroneous when entered and was based on the court's misapprehension that one daughter was to be living with Mr. Clay and 2 with Gloria. It can only have been the court's intention to award $562 per month temporary child support, reduced to two-thirds or $375 because of the mistaken impression that only 2 daughters were residing with Mrs. Clay. This was not the case when the order was entered, and it is difficult to describe how the error was engendered. Nevertheless, it is true that only one child has ever lived with Mr. Clay, and that was only for 2 weeks in January. Shocking. The appropriate figure should have been $562 per month, instead of $375 order and based on 2 children. This would yield a February through August 87 figure of $3,937.50. Another inquiry in child support arose once Mr. Clay returned to full-time status as the University of Illinois in September 1987. The statutory minimum for child support he should have been paying to Gloria, exclusive of any rental income, in the computation of available income for 3 children became $656.61. This is based on the 32% his monthly university net income of $2,051.93. This would yield a support figure of $3,283.05 for the period of September to the end of January. From February 87 to the present, Ernest paid the following amounts. February, $375. March, April, May, June, $375. July, $300. August, September, October, November, December, $375. January payment due on 22nd, $375. Total paid and due, $4,037. Totaling up the difference between the amounts actually paid and that due under a correct computation, based on who the children were really residing with, yields a deficiency of $2,713 in the statutory minimum of child support for the period, which this court is specifically authorized to correct by reference to the retroactive provision of the order of March 5th, specifically reserving the question of retroactive support. It is not only permissible but necessary to allocate the correct amounts to reflect Mr. Clay's actual income and Gloria's actual furnishings of support to 3 children. We argue the court to order that retroactively his support for the February of March through August be $562 per month, that the support from September and ongoing to $656.32 per month, and the arrearage and under calculations require an order for $2,713 for February through the present and to continue. This is exclusive of whatever factor that the court may assign for income from the rental holdings of Mr. Clay. We suggest that a realistic figure from the evidence would indicate a $1,500 to $2,000 net is indicated. This would yield an appropriate increment of $480 to $640 per month on top of the university calculations, both prospectively and retrospectively. As an alternative, if the court feels that the actual income of Mr. Clay's March 5th property hasn't been fully exploited, as per his poor mouth testimony about unrented units, an order for 32% of any present or future net incomes, setting out the elements legitimately deduced from gross and authorizing discovery by Mrs. Clay of the books of his operation, should be both equitable and enforceable. We also anticipate that these properties may well be sold by Mr. Clay to foil any argument that a percentage of his net income should be used for support. It is abundantly clear that during the marriage, these two people embarked upon the accumulation of rental property to define their lifestyle in large part. Their marital history sounds like they spent a lot of time watching late-night cable TV pitching and selling investment cassettes. It is obvious, however, that they were counting on their children benefiting from the real estate empire they were accumulating. It would be unjust to deprive those children of the benefit of Mr. Clay's real estate investment income by permitting him to liquidate it and do whatever with the funds. If he sells any present holdings, he should be ordered to immediately disclose that fact to Mrs. Clay and to give her an opportunity to claim against that liquidity for any arrearage which might be then in existence, or to make any other motion which seems appropriate. Any argument as to Mr. Clay's inability to pay adequate support to his children is inconsistent with 5 weeks of West Wing 2 luxury Bahama vacation property he was allocated in the March 5th order. The property is worth approximately $48,000 and in a pinch should be a nice cushion for his children's needs as well as his pleasures. Maintenance. The evidence makes it clear that Gloria Clay, though ambitious and hardworking, has not prospered as an entrepreneur or as a real estate agent, and that she is unlikely to gain employment in her field of training. This presents two alternatives: rehabilitative maintenance for the limited time of 5 years in the amount adequate to provide a lifestyle for Gloria compatible to that to which she was accustomed during her marriage, as well as provisions for